SJC-13515 in the matter of an impounded case.
Okay, Attorney Hollenberg. Good morning.
Good morning. May it please the court, Ilana Hollenberg on behalf of Appellant Respondent FA. Your Honors, Section 16E tells courts that they may order a civilly committed respondent committed under Section 16 restricted to the hospital and grounds, but it doesn't give them any information about when such an order is appropriate or what kind of process should be instituted for the court to determine.
So what do you think, what should the rules be? What should we tell judges?
I would like the court to tell judges that there must be an evidentiary hearing to determine whether there is a substantial and imminent, non-speculative risk to public safety attendant upon refusing to order it.
So did you finish answering Chief Justice's
Yes.
question? What I'm concerned about is the timing of this, and I agree that there's no standard, which is problematic, but you pose it as an imminent risk, but they've already been sectioned, right? So they've been found to be there's a likelihood of substantial harm, correct?
No, Your Honor.
So just walk me through the legal standards. What's the legal standard to get them there to be committed as a danger, which is much more intrusive, of course, than a building the grounds restriction?
It is more intrusive. I would not go so far as to say it is much more intrusive.
I don't know about that,
but I will not deal with that right now. I'll answer your question. So, in order to commit somebody,
right,
there must be proof beyond a reasonable doubt that failure to commit them would cause a substantial and imminent risk of harm either to themselves or to others.
Is it imminent, or is
imminent? Is this court has put in the term imminent. It's not in the statute, but now it is in the law. The harm must be imminent. That's GP, cited in my brief a number of times, matter of GP. So it has to be a non-speculative danger. It has to be imminent. It has to be, for prong 2, within days or weeks, not months or years. That's the standard for commitment. Now, not everyone who is committed is...
Right, what I'm wondering is...
Yes.
So now we have to have a second hearing and finding of dangerousness, essentially, for building the ground restrictions. The judge has already made that finding.
So there's a difference between somebody who is dangerous to let go home to their apartment or to a group home, and somebody who's so dangerous that they cannot leave the hospital without creating a risk to others. And this case is one that really shows how that can be, that you could have somebody who might become confused, go off their medication if they were not committed, right? Somebody who needs medical attention, somebody who needs support in continuing to take their medication, but who can be trusted to leave the hospital grounds, especially in a case like the one here, in which the hospital is going to make sure the person is supervised for many years.
So under your scheme, there's a finding that they're hospitalized, involuntarily hospitalized, right? Mm-hmm. And then the Commonwealth, as is the case, would move for building and ground restrictions, and then there'd be a second hearing where there'd have to be this finding and proof beyond a reasonable doubt for the restriction.
No, Your Honor. If there's going to be a commitment hearing, there could be a separate section of the hearing that addresses what are the risks attendant upon leaving the hospital grounds.
I'm being inartful, but so the judge can make the same finding as far as dangerousness of the patient, and then consider it in context of a building and grounds restriction.
So the finding of dangerousness is not that if somebody can be too dangerous to go home, but not too dangerous to leave the grounds, and that's the kind of, and so if you have somebody who's been proved beyond a reasonable doubt to need hospitalization because they'd be a danger to others.
I understood your brief. I'm just wondering how this works in real life as far as
In
hearing
real
those.
life, you could have.
And under your scheme?
Yes, in my scheme, it would be done the way we did it in my case in an earlier year, which is that there'd be a separate section of the commitment hearing that would address the issue of building and grounds.
Okay.
In which there'd be testimony about what the risks might be, what the hospital planned to do
But
to
counsel,
mitigate.
why do we need that? Why don't we already have that in the statute? Why does it others mean others mean others? I mean, the statute doesn't say others outside of the facility, right? It just says others, prong two.
Yes, I gather that, but, Your Honor, the reason we need it is because there is a remaining liberty interest under the Due Process Clause, according to this court and the U.S. Supreme Court.
But the respondent, pardon me, the petitioner has already demonstrated this under the highest burden that we have, beyond a reasonable doubt. So if beyond a reasonable doubt, the petitioning facility or the petitioner has met prong two, which, if I remember correctly, in this case, they satisfied all three prongs.
In
Wasn't
this
it all three?
case, I believe, Your Honor, this was a 6B. There was no hearing on whether or not there was proof that my client needed commitment because he waived his hearing.
Mm-hmm.
And so the 6B waiver, all that established was that the petition was sufficient on its face.
Okay.
It was like a complaint, right? And that my client was not contending against it.
Okay.
So there was no evidence of any of the prongs in my particular case.
Can I?
I'm sorry.
Go ahead, go ahead.
Yeah, one last question, I hope. Was Judge McGuigan right that this is an all or nothing proposition? Because once the judge decides there's no restriction, and the person could be unsupervised outside the wire.
Judge McGuigan was partially correct. She was correct that for that year,
Yeah.
right? Because of course there are repeated annual opportunities to put a restriction on. But for that year, it would be up to the hospital, which is also
But
part of
isn't
the
that-
government, the executive branch, to determine under what conditions my client, the appellant respondent, would
But
leave.
wouldn't a concern, I guess the judge could take this into account, that they have someone who is sexually dangerous, delusional, and has rape compulsions. Perhaps therapeutically, they could have some supervised integration, but no way should they be unsupervised. And by saying no buildings and grounds, I'm giving license to whatever the hospital wants to do.
Yes, and under Carrera, the Carrera decision cited by both my sister and myself in our brief, we have the discussion of a similar situation cited by Judge McGuigan, in which the court was told that it could not encroach on the executive branch's ability to do its job the way it saw fit. And so in this case, without evidence of an imminent risk and without evidence that the hospital would be remiss in doing its job, which is...
I'm not so sure she was wrong, but that's beside the point, because the case, there's no restriction right now because of the second commitment, right? As we stand here, there's no restriction.
You're asking if my client is currently restricted.
Right.
It's outside the record, but with your permission, I'll let you know he is, because there's been a subsequent order.
Okay, because, all right. But the judge can take into account all of these things as far as the lack of, basically you cede your discretion to the hospital, and they can have supervised or unsupervised, lack of restrictions, right?
Yes, I think that in this case, given the lack of any evidence of any recent, even within 15 years, dangerous behavior, the uncontradicted evidence of consistent medication taking, and
I'm not so sure you're right on the on whether her decision was clearly erroneous, but I take your point about this being a liberty deprivation. It's a substantive due process issue, and there should be a standard to apply.
Thank you, Your Honor. Are there any other questions?
Well, my question was the same as Justice Castellano, but I'm not quite sure I understand the answer. So if it is an all or nothing for that year, and the judge says, okay, I'm not comfortable with the possibility of completely unsupervised leaving of the grounds, is it an abuse of discretion then? Why is that wrong then? Because
Your Honor's question points out the very problem that is the main point of my brief, which is that the lack of standards in this provision means that you're wondering about abuse of discretion or whether a decision is clearly erroneous. But actually, what we should address first is whether the interpretation of the law is correct or whether the law itself, on its face, doesn't work because of the lack of standards.
you're agreeing with the Commonwealth and the judge that it is an all or nothing proposition, right?
As written,
So if, as a matter of law, the judge says, this guy's so dangerous that the possibility of him being out on his own, I can't allow. It just seems that seems reasonable if, doesn't it? I get your point, if it weren't all or nothing, that if they, I get your point that there's value of having him leave the building one-on-one, and even in a group with multiple things. But if the judge is worried about this possibility, and you agree it's possible too.
no, I don't agree that it's possible.
Why isn't it, how can it be
Because-
all or nothing and not be a possibility?
Because we have uncontradicted testimony, as well as the representation of DMH counsel, that it would be many years before the hospital would ever even consider allowing my client to leave the hospital grounds without supervision. And furthermore, as I'm sure you read in the briefs, there are many layers of internal DMH safety protocols, both clinical evaluations by non-treating doctors, the most senior non-treating doctors, as well as independent forensic risk evaluations by professional risk assessors. And those all have to take place even before, there has to be another enhanced clinical review in the absence of a building and grounds restriction.
But that's in the hands of the executive branch.
That's correct, but unless the executive branch has been determined to be remiss and unreliable, then it seems extremely unlikely that my client would be allowed outside the hospital without supervision for many years. I can't imagine a circumstance in which it would occur. And this is a client who the record shows has been cooperative, takes his medication, is engaged with treatment, and also has a limp, has difficulty walking, and has to be sometimes persuaded to walk with
But he was
staff.
disengaged in sex offender treatment.
He was described in the transcript as superficial in some of his answers, and the disengaged remark from the doctor had to do with whether he believed he needed both his antipsychotics. He hoped he could only take
He's
one.
actively delusional, though.
That is the one remaining symptom. And so if you look at this...
And there's a command control to rape, if that's part of his delusion.
That the delusion, as it was put in the record, is that not a command control to rape, but that the director could potentially control him, although by the time of
Rape.
the hearing in 2020,
To
the
rape.
testimony showed that he said he did not think he could be made to commit a violent offense or rape. So that was the testimony. I know the petition says something different, but that was not in the record. So we've got here a lack of standards that lead the judge to think about the index event in 1995, rather than about the uncontradicted testimony.
I agree. If there is a standard, it has to do with present danger.
Yes. And so we've got rule-abiding, cooperative, non-threatening, non-violent behavior from a person who's around 60 at this point and walks with difficulty after having had surgery and problems with his spine. And the doctors have offered to have him have one-on-one supervision for 6 months to a year at least, and not cease that unless it looks like he could be okay with the
Last
group.
question, I think, could the judge condition a ruling on supervision?
I'm sorry, could you?
Could a judge make a conditional finding? Could a judge say, I'm going to deny building and ground restrictions or deny the request for building and ground restrictions with the condition that it be supervised?
I,
Would that be an Article 30 violation?
if the judge had made that ruling, we wouldn't be here today. I wouldn't have appealed it, but I don't know whether the statute allows it.
Okay.
Okay,
Do you have any other questions for me?
thank you very much.
Thank you.
Thank you.
Attorney Riley.
Thank you, and good morning. My name is Patricia Riley. I'm an Assistant District Attorney for Plymouth County. A building and grounds restriction can only be imposed after a person has been civilly committed.
Do you find this to be a liberty violation?
I beg your
Or
pardon?
is this a restriction on liberty?
If it can be considered a restriction on liberty, and I say if, because it's totally to the discretion of the hospital whether or not to let
Okay,
a
but
person.
we can't deal with if, so if, either there's a substantive due process issue, if it implicates a liberty interest, or there's not.
It is not a substantial deprivation of liberty interest. However, even this court in I think it was in AZ, said that it could be considered, there are lesser liberty interests at stake. And I don't see how this actually can be considered a substantial deprivation of liberty, or even a minor deprivation of liberty, because it is up to the hospital. The building and grounds restriction is actually a restriction on the hospital. It's not a restriction on the defendant. It's telling the hospital, should you choose, if you think it's possible to let this person off grounds, we're saying no.
But that seems very semantical. I mean, it is a restriction on this particular person.
Not
They
really.
can't go off the building.
But only.
They can't have home visits. They can't go out into the community. And I get that maybe it's limiting the treatment options for the hospital, but it affects the individual. I don't see how this is going to
Well,
carry the day as to whether or not there's a liberty interest or not.
even if there is no building and grounds restriction, that person has no right to leave the facility. They have no right to leave the building and grounds.
But
Even
they
without-
have the opportunity to, which this would
Not necess-
eliminate it.
Respectfully, not necessarily. At the time of this hearing, no one was allowed building
But
off-grounds
That's in the
privileges.
discretion of the executive, right? You're just saying as a practical matter, the executive gets to choose, but the executive never gets that chance if there's a building and ground restriction.
Well, but they do. They can remove it. I mean, there's,
But maybe I'm so the person's committed, the DA's office is notified, the DA's office comes to court with a motion to restrict the person to buildings and grounds. Do I have that right?
it actually doesn't even have to be a DA's motion. The court may do it on its own.
Okay.
And
But, all right, but in this case, this is what happened, that's what happened.
in this case, this is what happened.
All right, because you folks think in your judgment, as people who are charged to protect the public, that this person shouldn't be in the community.
And it was after obtaining the medical records that showed that he's still
I'm
suffering.
not getting into the merits, but that's how that works, right?
Yes.
So the chief law enforcement officer in the county is saying this person shouldn't leave the perimeters of Taunton or wherever.
This is Worcester Recovery Center
Worcester
and
Recovery
Hospital.
Center.
That is correct.
Okay.
And there's a reason, I think, that the court should look to the language of the statute, and the reason the DA's office is given notice of all
I'm not
these.
saying it's a bad thing, because you're protecting the public is a good thing. But what I'm saying is, or what council's raised, is whether or not that restriction implicates a liberty interest such that substantive due process kicks in, and we should, as we've done in other cases, impose a legal standard so the judges aren't acting in an arbitrary fashion.
I think if there's a standard to be had, it should be a rational basis standard. This is the same type language. If it-
Rational basis is only applicable if it's not strict scrutiny, because there's no liberty interest.
But this is the same type of interest in probation. A person who's already been adjudicated and found guilty, and it's the discretion of the court, not the probation department, it's the discretion of the court whether or not to put conditions of probation on that person, or on pretrial detainees.
But in all mental health cases, where there's a liberty interest involved. We say there's a substantive due process issue. And we need, I get what you're saying, that it could be clear and convincing evidence, doesn't have to be beyond a reasonable doubt.
I would suggest to the court it should be reasonable. It should just be a reasonable, if the judge has a reasonable basis, and in this case, she heard evidence of the defendant's mental condition. And don't forget, these cases
And by the
are,
way, reasonable basis, is it this all or nothing? I mean, the question Justice Gaziano asked earlier, could the judge issue an order that says, no unsupervised visitation, but if you send her client out with one-on-one supervision, that's okay? Can the judge do that? Because I look at this as odd in one respect. DMH thinks it would be valuable and safe to have this person released on a one-on-one trip outside the grounds. The judge says, I can't allow that because there's a possibility that he would be released without supervision. I'm not sure could the judge have prevented that possibility?
no, Your Honor, not if,
Why not?
following the decision of the appellate division of the district court.
As much as we love them, we're completely unbound by them.
I understand, but they did say that it was,
Why can't we say, this is not, there's flexibility here to allow that kind of visit. And the judge has the flexibility to do something more than all or nothing and remand it and say, okay, now decide. What's that English?
If this court doesn't feel like it's intervening in the prerogative of DMH and how to treat their clients,
Well, the judge, we should be very hesitant to interfere with DMH, but we may say, okay, you have this much discretion, but this guy's a danger on his own. We're not going to allow that. And that's exactly what it looks like the legislature was worried about, that there's certain points where the judiciary needs to step in and protect public safety.
And I think that's why
But it's not when DMH says, we're not going to let this guy out without literally some, big guy standing next to him as he walks around the grounds. But we think it would help his mental health if he could leave the building. Why shouldn't we allow that?
I don't think that's a bad idea. However, also factor in the fact that the building and grounds restriction is also used on people who have been found incompetent to stand trial, who have open cases, who might have been found dangerous after a 58A hearing, that there are no conditions.
Well, but that's again, we're trying to provide substance to something that's pretty vague. But this all or nothing thing makes our life a lot harder, and I don't know the legal basis for it. And if it doesn't exist, you're both in agreement, and we don't need to do something hard on substantive due process.
I'm not sure what the question was, Your Honor.
The question is, why can't this statute provides the judiciary with substantial flexibility? Included in that flexibility is, okay, we will prevent a release that is dangerous to the public, but we have the ability to allow releases that aren't dangerous to the public. Because without that, you may have a substantive due process violation.
I think the practicality of how that could come about might be difficult.
Why?
For example, well, every case, as you know, is very, very different. So how, I would suggest that it would have to be after the imposition of a building and grounds restriction. If the hospital were to remove it, they could propose to the court the different conditions.
The first part of this thing is incredibly detailed and has a lot of process to it. Before we institutionalize you, there are all these very strict requirements. This little postscript doesn't have a lot of detail to it, but it's basically a safety valve for the judiciary to say, okay, this person is too damn dangerous to let out. But he's not too damn dangerous to let out in a supervised way. He's a 60-year-old man who can barely move, and it would benefit his mental health to be outside the building. So he has a liberty interest, a limited liberty interest that we can, it just seems like we're making this harder than we need to.
And also factor in the defendants, respondent defendants who are flight risks, who might have a bail status, who are argued to be.
They don't get out at all. The judges have this limited right to protect public safety here beyond the institutionalizing. Okay, this guy is so dangerous, but we're not ruling out this idea of limited visitation rights. I just don't see the basis in the statute that prevented the judge from doing that.
If the court were to allow that and allow the DA's office input based on, records research, and as we do with just the imposition of a building and grounds restriction, it might not be a bad idea. I think the fact that
Well,
FA could
our
get-
job is it might not be precluded by the Constitution, right? Our ability, we have to make this statute constitutional. And by pushing it as hard as you're doing, you may be raising a constitutional question that's unnecessary if supervised visitation is within the authority of the judge, right?
If supervised community access was within.
Yes, if the judge can not do an all or nothing, but allow a limited visitation, the right the judge has that's consistent with the Constitution is to protect the public from danger, right?
Yes.
But that's a right that, I don't know if it's subject to strict scrutiny, but if it is subject to strict scrutiny, this could survive strict scrutiny if we allow judges to do this more limited supervised visitation, which apparently you say is precluded by the appellate division of the district court's decision. I just don't know. I haven't read that decision, so I don't know.
Can I ask you just maybe a different question?
Certainly.
Do you agree that procedural due process requires at least a hearing and findings?
Well, the problem for that, Your Honor, is when the respondent waives his right to a hearing, but yes.
He waived his right to the commitment hearing, but this is a different hearing or a different finding. But assuming we believe that this is a different proceeding, it requires a different finding, do you agree that procedural due process requires at least those two elements?
Yes, but I would suggest it would be more like Schianti.
Which was the fault in the second proceeding. The judge made no findings.
That's
And
correct.
didn't have a hearing.
And there was no evidence presented. However, I would suggest it shouldn't have to be as formal. I mean, the Durling case suggests due process is a little bit more flexible. This could be more like a competency hearing under Commonwealth v. Schianti, which it allows for the judge to take, observation of court officers into account and more, gives the judge more discretion in a case like that.
Okay.
Do you have any further questions? Justice Georges, it sounds like.
I'm pained because I again go back to the other standards for when we curtail people's liberty this way. When you have the 7 and 8s, right, where there are specific findings that the court has to make about the danger the person poses, either to themselves or others, that we don't have here without a hearing. And so making these kinds of decisions in a vacuum really worry me as to okay, they waive their right to a hearing, but if you're going to curtail their liberty without any evidence about what danger level they might pose, what does that say for what we're doing?
I mean, the standard itself on commitment, whether or not they file a waiver, the standard is still there. We're ready to prove our case, or the hospital would be ready to prove their case. In this case, I think it was you who brought up, it was under all 3 prongs that this respondent was being committed. So, I mean, the standard still exists for commitment, whether or not they have an evidentiary hearing or not. If the petition, which is included.
Sure. But without any kind of finding, again, so there's no evidence other than just what's alleged in the petition.
The finding is on the order. The order says, basically, we have found that this person meets commitment criteria. And the standard for commitment criteria is very clear. Incompetent to stand trial or NGRI, danger to danger, and mandates hospitalization. So whether or not they waived their right, there's still a judicial order that found that through what was submitted to the court, a petition, which the respondent chose not to challenge.
So that subsumes whether or not we allow you to roam the floor, the building, or the grounds, whatever the discretion is as to the parameters of it.
Currently, and should the court want a hearing, as in this case, the Commonwealth was ready with the defendant's own doctor as our witness to show that, to bring that evidence in front of the court to kind of give a boost to the fact that he's still suffering from the same delusion he had back when he raped his mother. That hasn't, it's changed, it's tweaked a little bit, it fluctuates. He lives in a completely delusional world. We wanted to bring that out to the court because it's still very, very important. And we thought that would, the next year we were prepared to do the same thing. Well, I think it's in the record that we had a petition, we were ready to go, and there was a respondent wanted to argue on constitutional grounds that it shouldn't be allowed.
Thank you.
Thank you. If there are no further questions.